President Trump signed an executive order that excluded birthright citizenship. The next day, 22 states filed suit to challenge the executive order in court. Why is this suddenly an issue? Birthright citizenship? On his first day back in office, President Trump signed an executive order entitled Protecting the Meaning and Value of American Citizenship. This order excluded birthright citizenship from those whose mother was either unlawfully present in the United States or lawful but temporary, unless the father was a citizen or lawful permanent resident. The next day, 22 states filed suit to challenge the executive order in court. Some called it flagrantly unlawful. Others claimed Trump's action was an attempt to cancel the 14th Amendment. The core of the dispute goes back to the opening words of Section 1 of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The legal issue is that the condition for citizenship in the amendment is a compound statement. To qualify, one must be 1. Born or naturalized in the United States, and 2. Subject to the jurisdiction thereof. What, if anything, does the second part mean? Such disputes are common, particularly as time passes and considerations change. And what was obvious to those who enacted the law is forgotten. What was not an issue suddenly becomes one. The definition of birthright citizenship is a long-standing issue. Trump is not the first to raise the issue, but he is the first to try and settle it. And one way or the other, it will be settled. And the Supreme Court will have to tell us, 1. What subject to the jurisdiction thereof legally means, and 2. Does the President and/or Congress have any room to define this phrase? Here, the two views of the Constitution play a large role. A minority of justices see the Constitution as a living document and seek to understand what the phrase has come to mean. The current majority are originalists who seek to understand how the 14th Amendment was understood when passed and how that applies to the current question. The 14th Amendment's origins are found in the court's infamous Dred Scott decision, which ruled that one of the African race could not be a citizen. Thus, the driving reason for Section 1 was to overturn the Dred Scott decision by constitutional amendment. In 1873, Won Kim Ark was born in San Francisco to Chinese parents living in the city until 1890, when they returned to China. At that time, Won Kim Ark visited China and returned to America. In 1894, he again visited China, but when he returned, was denied entry on the grounds that he was not a citizen. When the Supreme Court heard the case, the court ruled in United States v. Won Kim Ark, 1898, that the 14th Amendment
must be interpreted in the light of the common law, the principles and history of which were familiarly known to the framers of the Constitution.
After a long review, Justice Horace Gray wrote of the amendment,
"Put it beyond doubt that all blacks, as well as whites, born or naturalized within the jurisdiction of the United States, are citizens of the United States."
As a result, the court ruled,
"The 14th Amendment does not exclude from citizenship by birth children born in the United States of parents permanently located therein, and who might themselves become citizens, nor, on the other hand, does it arbitrarily make citizens of children born in the United States of parents who, according to the will of their native government and of this government, are and must remain aliens.
The ruling was a clear victory for Won Kim Ark. His parents had been in the country legally for a long time, so he was a citizen by birth. It did not matter that his parents were subjects of the Empire of China. But what about the current dispute? From the text of the amendment and the court's rulings, it is wrong to say that being born in the country is enough. If it were, there would be no reason for the second clause. The children of those permanently here legally are citizens. The children of those here on behalf of their governments, such as ambassadors, are not. The question remains, what about the children of those here illegally, or those here on a temporary basis, such as a vacation trip? At best, this was left undefined. Thus, the court will have several options. Most likely, the issues of parents here illegally and those here on a temporary basis will be addressed separately. One, the least likely, is that they could declare the understanding that the amendment excludes those children. Two, another option is they can rule rightly or wrongly. The practice has been that children of illegals have been considered citizens. To change this now would be too disruptive, so these issues will now be a matter of constitutional law and outside the power of Congress or the executive to change. Three, similar to option 2, they could rule that this has been de facto law until now, but that given the ambiguity, it is within the congressional or executive authority to define this phrase. The key consideration here is that when there is ambiguity in the Constitution, who gets to settle the ambiguity? Is it only the Supreme Court? Or can the Congress and/or executive play a role? Note, they could take this option and still rule the executive order unconstitutional, as it would require Congress to define this. Though this would be more of a stretch, as presidents routinely have to decide on the exact meaning of a law to carry out their duties. We will have to wait and see what the court decides and their reasoning. Thank you for listening to Into the Desert, exploring the wilderness of thoughts. Don't forget to like and subscribe and put your comments below. Remember, be civil. We want to foster discussion and not division.